afternoon, everyone. Welcome to a new Policy Monitor webinar. This afternoon, we have a busy program as we will be discussing the AI Act, the EU AI liability proposal, and recent AI policy initiatives in the US and Canada. The webinar will be recorded, and the presentations and recording will later be sent to all participants and published on our website. I'll briefly go over the program now. We normally had Nathan Duhayon, advisor to MEP Tom van de Kendelare, as our guest, as the first speaker this afternoon. We were supposed to talk about the latest state of work on the AI Act in the European Parliament. But due to an urgency in the Parliament, he cannot be with us this afternoon. My colleague Thomas Gils will do his best to take over Nathan's role. After Thomas, David Scheere will take the floor. David is attaché at the permanent representation of Belgium at the EU and works for the Department of Economy, Science and Innovation at the Flemish Government. David will provide an update on the latest compromise text on the AI Act of the Council of the EU. Then Professor Jan de Bruyne will discuss the new EU policy initiatives on the AI liability. And lastly, Wannes Ooms, researcher at the Knowledge Center and Data and Society and CiTiP, will guide us through the United States AI Bill of Rights and Canada's AI and Data Act. After the presentations of David, Jan and Wannes, questions can be asked to the speaker. And you may post those questions in the chat box. I'll now give the floor to Thomas for the first presentation.
Yes, welcome all. I will try to take over the presentation of Nathan, as he already provided the presentation. But before going into that presentation, I will just provide you with a brief baseline understanding of the AI Act. So as you may know, in 2021, the European Commission provided a proposal of a regulation on AI, and the regulation rests on a risk-based approach, whereby certain AI systems are deemed unacceptable and are prohibited, for instance, social scoring or certain forms of biometric identification, and they are prohibited in every instance. Just below, there is a category of high-risk AI systems, and they are permitted, but will be subject to a whole list of compliance requirements and should also undergo a conformity assessment. Whether or not an AI system is deemed high risk depends on certain conditions. Either it should function as a kind of safety component for certain devices that fall under EU harmonization legislation, for instance, medical devices, or an AI system should be used in a specific sector and in a more specific use case, and then it can also be considered high risk, for instance, in the context of recruitment. Another category are AI systems that should comply with certain specific transparency obligations. In summary, that either refers to kind of chatbots or deepfakes. They should be clear about the fact that they are a chatbot or a deepfake. So they are permitted, but have to comply with certain transparency obligations. And then finally, all the AI systems that do not fall in one of the categories above, they are minimal or no risk and are in principle permitted without having to comply with other obligations. However, the underlying important question is what is or what is not an AI system. And as we will see, this is one of the hot topics that remains to be discussed both in Parliament as well as in the Council. Now, if we take a brief look to the obligations that would lie on the high-risk AI systems, we see that they are quite manifold, and for instance include risk management obligations, data governance, the need to draft technical documentation, record keeping, meaning that the logs of the functioning of an AI system need to be kept. They need also to install certain human oversight mechanisms, think about human in or on the loop procedures, and there are certain requirements with regard to the accuracy, robustness and cybersecurity of AI systems. And now those obligations in principle rest on the providers of AI systems, but there are also obligations that rest on importers, distributors, and users of AI systems, whereby it's important to understand that users in this context means actually deployers of AI systems and not really the end user or the consumer, let's say. Now, in order to compensate for those potentially heavy obligations on high-risk AI systems, the Commission also envisaged certain measures for innovation to support innovation. And that, for instance, could be a regulatory sandbox. But as we may see, that is also still a topic that is quite a bit under discussion. Now, if we then take a look at the state of play of the AI Act in the European Parliament, there are certain amount of consideration that have to be kept in mind. And just to be clear about this is the presentation that Nathan actually already provided to us. And I will try to guide you through the main points that he was planning to tell us today during the webinar. So first of all, it is important to understand that there is a joint responsibility in the European Parliament for this file. And so both the Internal Market and Consumer Protection Committee, IMCO, as well as the Civil Liberties, Justice and Home Affairs Committee, LIBE, are responsible for the AI Act. This means that there are not just 7 members of parliament that are involved, but 14. And this gets further complicated by the fact that also another range of parliamentary committees are also providing opinions. Moreover, the Culture and Education Committee, the Industry, Research and Energy, ITRE, and the Legal Affairs, URI committees also have certain exclusive competences on parts of the AI Act. So they also take part in the IMCO-LIBE negotiations as well. And this led to more than 3,300 amendments on the initial Commission proposal. And the key players in the European Parliament are, on the one hand, Brando Benifei from the SND fraction, and on the other hand, Dragos Tudorache from Renew Europe. Now, one of the main points of discussion, as I already briefly hinted to, is the definition of AI. As some of you may know, the Commission proposal actually entailed quite a broad approach and referred not only to machine learning approaches, but also to logic and knowledge-based approaches and statistical approaches. And in Parliament, there are, on the one hand, groups that support such broad approach, for instance, SND, Renew, and the Greens. But on the other side, there are also groups, for instance, the EPP and the ECR, that advocate for a more concise and narrow scope of the definition in line with the OECD definition. So really stressing the machine learning aspect of AI so that it should be a more limited definition. Moreover, as also stressed by Nathan, this definition is really important because this will not only have consequences for the AI Act itself, but also for future legislation. For instance, the machinery regulation also refers to the AI Act, or at least refers to AI as defined in the AI Act. So having that definition right is very important. Another aspect in this regard that is being discussed in Parliament is that the definition will be brought under the articles of the regulation itself and not in the annex, as is the case under the Commission proposal, because in that way the Commission should not be able to update the definition through implementing or delegated acts. Another topic that is also still under discussion is the classification as high-risk system for specific AI systems. Again, here there are 2 sides in Parliament. On the one hand, there are groups that want to broaden the scope of that list of high-risk sectors and have more sectors and AI applications under that list. And on the other side, there are, again, more or less the same groups, for instance, EPP and ECR, that advocate for a more narrow scope and only include AI systems that are actually or really high risk. And so relatedly, there is still quite a bit of discussion on what kind of sectors should be included in the list. And current amendments refer to, for instance, AI systems that are used in the context of democratic processes. Think about voting or election procedures, but also with regard to generative AI. So AI that can generate text or audio or video content, but that is, as said, still under discussion. Moreover, there is also a more general or fundamental discussion with regard to the point, if this kind of sectoral approach, so where there is a sector in the list and then a specific use case, and if your AI system falls under that use case, you are considered high risk, shouldn't be amended by adding a kind of additional consideration whereby concrete applications under such use case should actually indeed pose a significant risk of harm to the health and safety or a risk of adverse impact on fundamental rights of European citizens. And only if that consideration is also fulfilled, then it is actually deemed high risk. Now, again, that the addition of that consideration is still under discussion, and that may be understood as a kind of bargaining chip by the EPP in negotiations with the other fractions in the European Parliament. But it will be interesting to see how that actually will turn out, because this kind of self-assessment may not be that evident. Another hot topic is biometric identification. As some may know, the Commission initially drafted a prohibition for the use of real-time remote biometric identification systems in publicly accessible spaces for the purpose of law enforcement, with certain exceptions. But the European Parliament seems to be leaning towards a complete ban of that kind of systems. So they're not only aiming to prohibit the use, but also the placing or making available on the market and the putting into service of biometric identification systems. And they left the real-time requirement out, and so they only refer to the remote biometric identification. So that also includes ex post identification. And then finally, they also included privately accessible spaces, which is then broader than the strictly publicly accessible spaces. And in that regard, it can indeed be understood that they may be going towards a complete ban. However, what is not yet clear is whether, for instance, biometric categorization or recognition will also fall under that term of biometric identification. That is still up for discussion. Now, apparently, there are still some actors in Parliament that would support the Commission proposal, so a more narrow prohibition, but they appear to be losing ground. Then another topic that is has been debated very recently, because apparently even at the start of this week, amendments have been filed in this regard, is the topic of governance and enforcement. The rapporteurs, for instance, suggested to establish an AI office, which could resemble the AI board as envisaged by the European Commission. So it should become some kind of EDPB, European Data Protection Board, where national supervisory authorities gather in order to further inform European enforcement. However, that is still up for discussion again, and especially the legal status of such office is still being discussed, because most groups in Parliament, they do not really want to establish a new EU agency or body, but at the same time, there is consensus that certain additional powers or competences should be granted to the European level in order to guarantee a more effective enforcement of the AI Act. Furthermore, they also suggest unannounced on-site and remote inspections. Think about dawn raids under competition law. They also are advocating for the establishment of a pan-European database for high-risk systems. So not only for standalone high-risk systems as under the Commission proposal. And moreover, they also appear to be, so not only standalone high-risk systems, but also integrated AI high-risk systems. So that would be a considerable amendment of that requirement. And then additionally, they are also planning to introduce some kind of obligation that high-risk users should also register themselves in this kind of database. And then they refer to, for instance, certain public authorities, that they should be registering themselves in that database as a high-risk user. Moreover, they also further reinforce the idea of post-market monitoring, which already under the Commission proposal was suggested. And also under that proposal, the Commission plans to provide some kind of template of a post-market monitoring plan. But now the Parliament has further specified that such post-market monitoring should also take into account the AI environment, so including other devices, software, or AI systems with which the AI system interacts. So again, this is quite an interesting addition, because one can indeed question how that will have to happen in practice, and how AI providers can fulfill such requirement. And finally, they also introduced an individual right to lodge a complaint with an administrative supervisory authority, because apart from such right, there is still the possibility to lodge a judicial remedy, so with a court, with a judge. And the amendments to the AI Act in Parliament also established certain procedural guarantees with regard to that right to lodge a complaint. Finally, Nathan also provided some perspective on the next steps that may be taken in the European Parliament. Due to the fact that there are many technical meetings currently at a rate of 2 per week, it is known that there are still many issues to be discussed and to be sorted out. And although they originally planned to have a joint IMCO-Libe vote at the end of November, that will not be possible. And so probably the earliest they will vote on the Parliament on the committee position on the AI Act will at the earliest stage be in February probably, and that could then lead to a plenary vote in March, so that trilogues would start under the Swedish presidency around Easter. But whether that will turn out to be true will remain to be seen, but let's see how that will indeed turn out. And then so this was the presentation on the Parliament. And then I gladly give the floor to David, who will guide us through the state of affairs at the Council.
Yeah, thank you, Thomas. I will now try to share my screen and my presentation. Does it work? Yeah, okay, perfect. Let's go back a bit. Okay, so thank you for the presentation, Thomas. Hello, everyone. My name is David Scheere. I work at the Flemish Department of Economy, Science and Innovation, where I am a policy advisor, and I am also a part-time attaché at the representation of Belgium to the European Union to follow up on a selection of important digital European files for the Flemish Government, which includes, of course, the AI Act. And so we'll be talking about how the AI Act has gone through the Council of the European Union, which is admittedly a very vast subject. So I will stick to a few of the most interesting points and discussion subjects. And also maybe good to say is that I have used AI generative systems to come up with some of the illustrations in my presentation. So if you see some weird images, don't worry, it's the AI system that made it. And you will also see that I've put a prompt that I used underneath. And so, of course, there is no single AI presentation without a stock photo of a white microchip in the form of a human brain, which you can see here. And so, first off, the Council of the EU. So what is the Council? Very quickly, it's the European institution where the governments of the 27 member states come together to negotiate legislative proposals. They also do other things, but let's keep it simple. There are 3 levels. So you have at the lowest level, let's say the one that does most of the work are the working parties. That's where the administrations, so the ministries of of all the European governments come together to work on specific legislative files, which in this case is the AI Act. Then above that, you have the COREPER, which stands for the French words, Comité des représentants permanents. And that's where like the ambassadors of the countries come together to talk about some of the more political points in certain files. And then finally, when they have, let's say, agreed on the files, it goes to the last and the highest formal level, which is the council, the actual council. And that's where the ministers of the governments come together to approve certain European files. And so the council is also chaired by what's called the rotating presidency. So every 6 months, it's a different country. And until the end of this year, it's going to be the Czech Republic, which is why you can see the Czech flag. And after that, it will be Sweden, after that Hungary, and at the beginning of 24, it will be Belgium's turn. Okay, so a quick timeline for the AI Act in the Council. As Thomas already said, the AI Act was proposed by the European Commission in April 21. And at least in the Council, the first, let's say, months were slow and difficult. It took a while to get the discussions going. But then in June, the then French presidency of the Council proposed the first compromise text, which is the first text that pretty much brings together all the comments, inputs, and positions made by the countries. Following that, the Czech presidency took over in July, put out an options paper where they basically asked the countries their stance on a few very important policy questions related to the AI Act. And based on that, they came up with a second, then a third, fourth, and now fifth compromise text. And so that last compromise text was agreed by this ambassador level, so the COREPER, last week on the 18th of November. And all the relevant ministers of all the EU member states governments will sit together in the Telecom Council on the 6th of December, where they're very likely to agree the general approach, which is the Council's final position on the text. And then, of course, it's, well, we have to wait for the Parliament in order to start the trilogues. So now I will just cover a few of the maybe more interesting sticking points, the discussion points of the AI Act in the Council, with the first being the definition of AI. And so as Thomas also already said, the Commission has defined or tried to define AI by listing certain techniques and approaches. These were the machine learning approaches, the logic and knowledge-based approaches, the statistical approaches. But of course, there was a lot of discussion about this way of handling it. And there were fears about the clarity of this definition, the scope. There's always the issue between going too specific or staying too broad. If your definition is too specific, you might capture or you might not capture certain systems that could also maybe or would also maybe need to be defined as AI. And if it's too broad, well, of course, you're going to capture too many AI systems. And you might also capture, for instance, what you can put between brackets, classical software, computer programs that we do not want to be classified as AI. Another big sticking point was the concept of autonomy. Should we put it in the definition? Should we keep it out of it? What level of autonomy is necessary? And so you can see that there have been, throughout the various months, 6 different iterations of the AI's definition until we came up with a final version. I'm not going to read it out loud in the interest of time. You can find it online. I will provide all the links afterwards. But let's say that the current version is stitched together and cobbled together based on, well, let's say a long and difficult process. The next point is general purpose AI systems. So the picture, well, it's Dolly coming up with a cyber robot octopus. But anyway, so GP AI systems. What are GP AI systems? They are general purpose AI systems. They have become increasingly present in the discussions around AI. And so they are becoming an important part of the very complex value chain of AI systems and how they are used. And so what they are is that they are massive pre-trained models that can be used in hundreds or even thousands of downstream applications. And the big issue with these general purpose systems is that they have no intended purpose, while the AI Act was actually initially built on the concept of intended purpose. It's based on that you can classify the AI systems in high risk or any other category. And so these GP AI systems were not mentioned at all in the initial proposal of the Commission. Then in the first compromise text of the Council, they were explicitly excluded from regulation. And subsequently, they started to become regulated in a separate chapter specifically dedicated to these general purpose systems. But in a, let's say, strange way, they would just, in essence, be subjected to a few of the requirements for high-risk systems. But it wasn't very clear why especially would be these requirements, why not others. And so it was very difficult within the Council to find consensus on the issue. And so what has been decided in this final approved text is that the Commission, with the input of member states, will have 18 months to further decide how explicitly to regulate these systems through implementing acts. And so, yeah, in essence, the Commission and all the member states here are kind of kicking the can down the road. They're keeping it for later. And there was also decided now to already put in a certain escape hatch. So the providers of high-risk general purpose AI systems would be able to actually escape from this specific regulation that will be implemented in 18 months if they explicitly exclude in good faith any use of their general purpose AI systems by downstream users of the GPAI. Next, we have high-risk systems. So the actual issue there was the classification of artificial intelligence systems as high risk. And we can see that in the initial proposal, it was pretty simple. You could add two main options or two main ways to classify a system as high risk. The first one being if the system is used in a context that already is covered by European Union safety legislation. For instance, you can think of, let's say, medical devices, or you can think of car safety or product safety or stuff like that. Or the other option was if it was used in one of the use cases of the famous in certain circles, Annex 3. And Annex 3 is actually an annex to the AI Act where you can see a lot of different instances or cases where an AI system should be considered as high risk. So there also you can think of AI systems used for HR decisions, for employment, for instance, or for the management of critical infrastructure, or used in migration and asylum instances, etc. And so after that, you had, of course, discussions. And the discussion centered around the fact of the introduction of a horizontal layer. So the idea was that this Annex 3 and all these various use cases, that it would be too broad and too easy to capture all the AI systems that could be used in any of the use cases for Annex 3. And so the idea was to add a horizontal layer, which would give, let's say, an extra criterion that an AI system had to comply with before it could be classified as high risk. And so the idea was to say that the AI system had to have an immediate effect, so there would be no human in the loop, or if there was a human in the loop, the AI system should consist the sole basis of the action or the decision taken by the human. And only in those cases could it be high risk. Then that was subsequently changed as well. And now the current and final version says that if an AI system is used in a use case of Annex 3, it will be high risk unless its output can be considered as purely accessory to the effect or the human taking a decision. And what purely accessory means, and you can see the little man kicking the can, will also be decided by the Commission through implementing acts in the next 12 to 18 months. So again, we have a little case of putting off certain critical issues until later. Some animations. The next slide then, and the next topic is enforcement. Here as well, lots of discussion between mainly should it be enforced at the national level or at European level, and then various, let's say, modalities of these two. So the initial proposal strongly anchors the enforcement of the AI Act, so ensuring that it's applied well and also, of course, imposing sanctions if it's transgressed. The initial proposal anchored all of that strongly at the national level, with some EU cooperation via the AI board, which is a body representing the member states that is created through the AI Act, and also via a procedure for AI systems presenting risk at national level, where national authorities had to inform the Commission and other authorities of, let's say, the most dangerous AI systems. Now, you could see at the Council that there were quite a few countries, especially the smaller ones, that had desires for more centralization at the EU level. Some of the arguments there referred back to the GDPR, because there as well you have enforcement that is strongly national, and you can see that there is a lot of divergence within the European Union, with some countries enforcing a lot, others not enforcing at all or barely, different ways of applying the GDPR. And so here the argument was that we need more uniformity to enforce the AI Act, and so you would need more enforcement at the European level. There's also, of course, the big question of the lack of resources and expertise, especially in smaller member states, to go out and start to enforce, study, to basically comprehend the AI market in your country and to enforce it adequately. And so these arguments were heard. And so the current text is, let's say, a compromise between the two. So the enforcement will still be done by national authorities, but the AI board has been strongly empowered to facilitate the consistent and effective, not effective, but effective application of the AI Act. The Commission is supposed to issue guidelines on uniformity, so on to be sure that concepts are applied in the same way throughout the Union. And there is also now the possibility for the AI board to request the Commission to establish what is called a central pool of independent experts. So these would be people with a lot of expertise in AI to go out and help certain member states at the request of these member states with issues related to enforcement. And this will also be done via implementing acts. Voilà. The next sticking point is about AI regulatory sandboxes. So very shortly, what are sandboxes? Sandboxes are, let's say, measures to boost innovation. And there are physical or virtual environments where companies can test and validate innovative AI systems. And they are supervised by authorities while they do so. And it's a way for these, let's say, systems to check if they are compliant with regulation, if there are any enforcing consequences to their use. And it's a way as well for the regulators to stay at, let's say, the cutting edge of the technology and to be there when the most innovative systems are being deployed. And so here as well, there was a big discussion between, let's say, the extent to which this needs to be harmonized at EU level, or the extent to which national member states have the flexibility to determine the conditions for application, the modalities of the duration of who gets to enter the sandbox, of the amount of publicity the projects running there have to get. And so let's say again that the final text is again a compromise between these two. So the current AI Act general approach of the Council contains the key guidelines for these regulatory sandboxes, but it also once more gives the Commission, let's say, the task to adopt the final detailed modalities and conditions for the establishment and operation of these AI regulatory sandboxes through implementing acts. So again, down the road in 12 to 18 months. And there are already pilot projects running across the EU, most notably in Spain. And I think the idea is also to look at how it goes there before adopting these implementing acts with further details. And so all of this brings us to our concluding remarks, which is first that you can see that the AI Act in the Council has led to a lot of kicking the can down the road. A lot of, let's say, of the more difficult questions have been sent to implementing acts, so the Commission will have more time to come up with solutions. This can be seen as the easy way, but it's also maybe the most pragmatic way, because you can keep on discussing about these things, and in the end, the sector is still fully evolving, and it might be necessary to actually buy some time and look later to see how to regulate these things. Another important thing is that we, of course, have to think about the Parliament and what they're doing, as Thomas described, and that, of course, in 23 there will be heavy discussions, I suspect, between the Council and the Parliament to come to a final agreement. For the timing as well, we're looking at the AI Act only entering into force, I think, at the end of 23 or the beginning of 2024. And then you have to remember that if these implementing acts are actually taken into account for the final text, you will need 12 to 18 months more before the full, let's say, regulation enters into force. And then lastly as well, there's a little maybe discussion or question point that does not have an answer, but it's the question that, with the AI Act, the EU wants to be the first and foremost regulator of a very innovative technology. Without itself being the biggest innovator, of course, you would have to look to the United States or China to actually look at the markets where AI is being developed in the most striking and innovative ways. And so there's, of course, a big discussion about, how should you regulate without being a large innovator? And then finally, as well, I've put a link to Kai Zenner's blog. Kai Zenner is the head of office of Axel Voss, who is an MEP who works a lot on the AI Act. And actually on that website, you can find all the documents that you would ever need, including all the council documents, the compromise text, and all the text you would need from the parliament as well. And this will conclude my presentation. Thank you.
Thank you. And I will go to Jan, who will guide us through some of the recent AI liability initiatives.
Okay, thank you. I will share my screen as well. Yes, normally you should be able to see it, right?
Yes.
All right. Yes, thank you for having me as well. And I think it's a wonderful initiatives to group all evolving initiatives on this on the AI Act in general, and then more specifically, what I will talk about the AI liability directive. Considering the time, I will talk very shortly, but of course the slides can be shared afterwards for more information. So as you know, in September this year, the European Commission proposed two new directives. The first one relates to the revision of the product liability directive, and the second one imposes a AI liability regime for extra contractual liability claims. Now, of course, these two proposals did not come by surprise. There have been a lot of initiatives the recent years regarding liability for damage involving artificial intelligence, and expert reports by the expert group, but also the resolution by the European Parliament in 2020 focusing on the role of operators and so on. And the reason why we see so many initiatives actually relates to the characteristics of artificial intelligence that make it difficult to find the responsible person. For example, this black box ID, self-learning abilities, all of these elements make it difficult to trace back the potential wrongful behavior towards a human, which is, for example, under fault-based liability still required. So considering all these gaps and all these difficulties, it is no big surprise, as I mentioned, that the European Commission proposed two new directives. The first directive is the AI liability directive, and it's just a proposal, of course. And I will just sketch the most important findings of both proposals. But in both of these proposals, disclosure of evidence is key. In this AI liability directive proposal, Article 3 imposes that the specific party, for example, a provider or a user of a high-risk AI system, has to disclose certain information. This, of course, relates to the information asymmetry, the lack of information for weaker parties and victims. So the idea is that those parties that possess information, providers, developers, and so on, provide information to claimants or potential claimants. Of course, this is a far-going measure, and this is why there are some safeguards. For example, a claimant must have taken the attempts to contact the provider to get this required information. Also, for the potential claimant, there are certain guarantees, certain measures that the potential claimant needs to follow before the court can order a specific party to disclose this information. The disclosure of information is also restricted to what is necessary and proportionate. So there we really see in this initiative that the European Commission aims at finding the balance, making sure that those weaker parties have sufficient evidence, sufficient information to make their claim, but at the same time also making sure that innovation is not hampered, protecting the SMEs, protecting providers or users of high-risk AI systems. So the disclosure information is the first important element in this AI liability directive. A second element, and this is also related to one of these characteristics of artificial intelligence, that it turned out to be difficult to prove where things may have gone wrong in the AI supply chain. One of the basic principles of procedural law is, of course, that if you incur the damage, you have to prove it. You have to prove the fault. So this is why the European Commission proposes a presumption of causality. It does not really go towards the reversal of the burden of proof. This could be the next step, but now it comes again with the presumption of causality. And you can see it on the scheme that several conditions need to be met before a claimant can benefit from this presumption of causality. For example, they still have to show a fault, which is still very challenging, I'd say. For providers, there's also a difference between providers and users, where the fault must come from a failure of the AI Act. For users, it can come. So still a lot of unclarities as well. But you need to provide a fault. You need to prove that you incurred the damage, and you need to show that there's a reasonable presumption of causality that the output of the AI system influenced your position. Now, if all these conditions that the claimant still has to prove are met, then the presumption of causality between fault and the failure or the output of the AI system is presumed. Again, I think that the presumption of causality does apply to make sure that innovation is not hampered. And this is why the Article 4 provides a lot of exceptions as well. The first one, of course, is that the defendant can still rebut all of these requirements. There's also some situations for non-high-risk AI systems and so on, to really make sure that you have this balanced approach. So when it comes to the AI liability directive, the disclosure of evidence and the conditional presumption of causality, which applies when certain conditions are met, is a way forward to remedy this weak position of victims, of injured persons. When it comes to the revised PLD, a good thing is, and this is of course my personal opinion, is that I think that the previous proposal will create a lot of challenges, because you have to see all of these elements in light of the lack of harmonization of tort law or extra contractual liability, which is still very much national law. But I do think that the revised PLD provides some solutions that are necessary in an AI age. I will not go into detail, but for example, software is included as a product, and this is I think far going, because there's been a lot of unclarities regarding software, but now it is explicitly included as stated being a product. Also, to define the defectiveness of a product, we refer to the legitimate safety expectations, but there as well, the possibility for self-learning, the possibility for further learning of AI systems is clearly taken into account, and clearly shows the ambition of the revised PLD to take technologies and so on into account. So a lot of interesting, innovative, necessary elements are included. In addition of these remedying of the gaps that existed, for example, is software a product, has now clearly been given an answer. Again, the revised PLD provides a disclosure of evidence. I will not go into detail there, but again, the court can order that the defendant provides information to the injured party, but again, there are safeguards. For example, the claimant has to present facts and evidence to support the plausibility of a claim to the court. So again, this well-balanced, I think this is the key in these two proposals, is this balanced approach. Finally, and this is even very far going, I reckon, is that it also includes presumptions of causality and presumptions of defectiveness. So the claimant has to prove the product's effect, the damage, and the causality, but the directive provides, again, presumptions of defectiveness of the product under certain conditions that you can see, and presumptions of causality when certain other conditions are met. So I gave you a very brief sketch of the main provisions of this AI liability and the revised PLD. I think a lot will happen in 2023 on the discussions, interpretations, because there is a lot of unclarity on both of these proposals. But most importantly, they remedy certain gaps, product liability, software qualification. They provide a disclosure of evidence towards the weaker parties, and they also work with presumptions of causality and defectiveness in both of these instruments. I look forward to your questions or unclarities afterwards, but I'm now happy to give back the floor to Thomas and to Wannes for the more comparative approach on AI.
Yes, indeed. Now we'll have Wannes Ooms, another researcher at the Knowledge Center Data Society, provide you with some insights into some recent transatlantic initiative, more specifically the US AI Bill of Rights and the Canadian AIDA. But I will let Wannes explain you what that is.
Okay, thank you, Thomas. We'll indeed be taking a look in this final part of the Policy Monitor update at the Canadian proposal for an Artificial Intelligence and Data Act, which is indeed called the AIDA, and we'll also look at the US blueprint for an AI Bill of Rights that was issued by the White House in October of 2022. We'll start with the Canadian proposal for an Artificial Intelligence and Data Act, which from now on I'll refer to it as AIDA. This proposal is currently in its second reading at the Canadian House of Commons, so still very much in its legislative process, and it sets out common requirements for the design, development, and use of AI systems in Canada. In addition to those common requirements, it also sets out some prohibitions for specific uses of AI systems. Similar to other AI regulations that we're seeing, the AIDA also uses a risk-based approach in which high-impact AI systems are subject to stricter obligations and to more obligations than non-high-impact AI systems. But here also, it must be noted that some cans are being kicked down the road. For example, the criteria that will be used to assess whether a system is high impact or not. That still has to be determined by additional regulations and is, of course, therefore still a source of legal uncertainty. But what are the obligations then imposed on these two types of AI systems, regular, let's say, and high impact systems? In general, persons responsible for any AI system would have to assess if their system is high impact or not. In addition, if an AI system uses anonymized data, then those persons have to establish the measures for the way in which the data is anonymized, and also the measures on how this anonymized data is then used and managed by them. Finally, the responsible persons will be subject to general record-keeping obligations for this high impact assessment and for the measures related to anonymized data. They may also be subject to additional record keeping if that is required by additional regulations that could still be brought into force by the Canadian government. A high impact AI system then, as already mentioned, is subject to more obligations and restrictions. Persons responsible for these high impact AI systems must take measures to identify, assess, and mitigate risks of harm or biased output from the systems. They have to monitor these risk mitigation measures and their effectiveness, as well as keep general records describing the measures. Again, here they may also be required to keep additional records if additional regulation is brought into force. Also, both providers and operators of high-impact AI systems will have to publish a plain language description of the system on a public website and include several things in this description, such as an explanation of the use or intended use of the AI system, the type of decisions and recommendations that the system could make, the risk mitigation measures that they've put in place for the system, and any additional information required. Finally, persons responsible for a high-impact system will also have to notify authorities if the system results or is likely to result in material harm. The AIDA also contains some provisions on its enforcement, aside from these obligations that we just discussed. For example, the competent minister can demand persons subject to AIDA to provide general records, can arrange audits to test their compliance with AIDA, and also, following such an audit, can require the responsible person to implement risk mitigation measures for problem points found in the audit. There are additional enforcement tools for high-impact systems. This could include the provision of additional records, but it could also include, if there is a serious risk of imminent harm, the order to cease the use or the making available of the AI system in the country. Finally, persons could be required to publicly publish non-confidential information relating to their obligations and to the requirements that they face under AIDA. There are also some provisions on the confidentiality of information that is given to the enforcers. For example, they have no issue sharing it with for a subpoena, for example, or for analysis by the administration, and they can even share relevant information, including personal and confidential information, with other government instances if reasonable to stop infringement of other laws. The minister then can also publish non-confidential information for example, on a breach of the ADA, if this is in the public interest, and they may also publish information on the AI system if there is a serious risk of imminent harm that might be prevented by this publication. Non-compliance with the ADA can result in some serious fines. As you can see on the overview, the fines can amount to up to 10 million Canadian dollars, or 3% of an organization's gross global revenue. And of course, we have these prohibitions that I already mentioned at the start, where the ADA prohibits the possession or the use of illegally obtained personal information for AI systems, and also prohibits knowingly or recklessly making available AI systems that are likely to cause serious harm or damage to property, or with the intent to defraud the public. Fines for those specific violations are even higher, going up to 25 million Canadian dollars. Now, since the ADA is still in the legislative process, it'll be interesting to see how it further develops over the coming year or years, and especially how Canada will assess when a system actually is defined as high impact under this act. We move a bit south then to the US, where the White House Office of Science and Technology Policy has indeed recently released a blueprint for an AI Bill of Rights. Very important to note here from the start is that this blueprint is a non-binding white paper that should not even be considered official US government policy, as it itself states. The blueprint also mentions exceptions for law enforcement and national security, and that alternative safeguards and recommendations are more appropriate in those matters. But moving aside from the exceptions, what's actually in this blueprint, there are 5 principles for the design, use, and deployment of automated systems. For each of these principles, the blueprint sets out its importance, the expectations it has to apply these principles to AI systems, so in other words, recommendations, and also some real-life examples of where these principles are already relevant now for AI systems. In the interest of time, we will only discuss the specific recommendations that the blueprint sets out for the principles, since these are also the most guiding part, let's say, of the blueprint. As a first principle, the blueprint urges the implementation of safe and effective AI systems. For that reason, developers should proactively protect the public by organizing public consultations, pre-deployment testing of the AI systems, as well as identifying risks and mitigating them during the development process. They should have ongoing monitoring and organizational oversight over their systems, and of course the data used should be of high quality, and the systems themselves should allow for an independent evaluation. For the second principle, the blueprint pushes for protection from algorithmic discrimination, meaning that automated systems should be designed and deployed equitably and not result in unfair discrimination. Developers and users should here implement proactive equity assessments for their systems and test them for inequities between groups. The data used in these systems should be robust and representative, and the system itself should be subject to independent evaluation, as well as reporting and monitoring to assess for algorithmic discrimination. The blueprint also sets out recommendations for its third principle, data privacy. Here it recommends built-in protections in the system, data minimization, and use limitations to protect the public's privacy. This includes privacy by design and default in automated systems, and strong data security to be implemented by developers and users. Consent for data collection should be of high quality, and for sensitive data, the blueprint recommends ethical reviews, additional necessity limitations, and further use prohibitions. Moving on then to our fourth principle of this blueprint for a Bill of Rights. Here it states that persons impacted by automated systems should be given clear, timely, and understandable notices of use for automated systems and clear explanations of the systems. This documentation should be public and easy to find, and also provided in plain language, and should assign an accountable person and be specific to the decisions, the behaviors, and the risk of the system that it's explaining or that it's giving notice of. Finally then, we have our last principle of the blueprint, which is that persons should have access to human alternatives, human consideration, and to fallback procedures. Meaning that humans, not only handling automated systems, should be trained in the system, but also that the systems should have human oversight and have fallback remedies built in with human consideration in the case of a failure, an error, or an appeal of decision. Especially in sensitive domains, such as health, for example, human oversight should keep automated systems narrowly scoped and situation-specific, and ensure that there is human consideration in high-risk decisions. It's clear from these different recommendations that there are strong similarities and perhaps inspiration from the blueprint and other proposals for the regulation of AI elsewhere in the world. Still, we should remember that this blueprint currently is a non-binding paper, so it's unclear to which degree it can and will influence development and use of AI in the US. While there are existing sector and state-specific regulations on AI in the US currently in force, it remains to be seen if we'll see a more general, perhaps federal regulation that's actually accepted and implemented there. Then one final interesting thing to compare this US blueprint to is a non-paper that, according to directive, was sent to EU government officials from the US in the same month as the publication of this blueprint, wherein the US argues for certain changes to the AI Act that would somewhat limit or narrow down its application. As you can see in this overview, they argued, for example, for a narrow definition of AI that was more in line with the OECD definition that we also discussed at the start of this presentation. The US also urged for broader exemptions to general purpose AI and to the obligation placed on those providers, for example, avoiding placing risk management obligations on them and avoiding placing obligations on them to cooperate with users in the EU for AI compliance, and also urging for a more individual approach to risk assessment, where, for example, a human rights risk assessment wouldn't always be required, and where US standards could also be considered a viable means to prove compliance over, or rather instead, of the self-assessments in the AI Act. So in conclusion, we see that the US government in its blueprint really pushes for principles for a fair design, use, and deployment of automated systems domestically. But at the same time, we do see that there is this urging towards the EU to ease a bit its proposed restrictions, presumably not to exclude cooperation with the US or to exclude trade aimed at the EU from the US by major US AI providers. On that note, I'll end my presentation and pass it back over to Thomas and Frederik for some Q&A, because I believe there have been some questions in the chat.
Thank you very much, Wannes, for your presentation. We still have a little bit of time, so we can have a look at the questions. There are two questions on general purpose AI systems. The first one, does the current proposal on general purpose AI systems still respect a risk-based approach? I will direct that question to David. David, can you have a look at this?
Yeah, so the current text in the AI Act, the current text in the Council, which was approved, does kind of follow the risk-based approach. So the idea is that general purpose AI systems are, let's say, too complex, and the relationship between the original developer and subsequent downstream users of the general purpose AI systems are too complex to just classify it as any high-risk AI systems. Also because it can be used for both high-risk purposes and non-high-risk purposes. So the idea now is that in these implementing acts that will come within 18 months of the entry into force of the AI Act, the Commission will look at specific requirements for general purpose AI systems, and will also for that take into account, let's say, the relationship between the developer of the system and the provider. So let's say it will remain to be inspired by the risk-based approach, but truly we will have to wait at least 2 more years before we can see how exactly the Commission plans to regulate these general purpose AI systems. And I think that's for the best as well, because they are very complex systems and they will need some further work. Voilà.
Okay, thank you. There's also a second question on general purpose AI, more specifically about Article 4C. The provider is here obliged to stop misuse committed by an unrelated third party. How can this be achieved in practice under the current law? David, can you also have a look at this one?
I'm reading the question again. Yeah, that's a good question, and that is indeed a risk. Part of drafting legal text is ensuring that loopholes are closed, and this could be one of these. I can say that yes, there is a risk that this voids the exclusion. You can find more examples of potential loopholes in the text. That's also why there's still a negotiation planned with the European Parliament. And there are also these implementing acts which might still, let's say, provide a way to close certain loopholes. I can't go any further into this question. Thank you.
Thank you very much. Then there was one more question about the ISO standard. How does the current text interface with the ISO SC42 work? Jan, I believe that question is for you.
Yeah, I try to take it. I'm not sure whether I'll give a sufficient answer, but I'll speak more generally on standards under the AI Act. The AI Act is one thing, but now standardization will become like key. We have all these obligations. Standardization bodies within the EU are now tasked to provide standards. Senelec and ETSI, I think, are now required to develop standards and have like a mandate now. So of course, the AI Act is linked to European standards, but they in turn are linked, of course, to more international initiatives. So standardization will become key, will become more important, has been criticized as well because of lack of transparency, democratic processes and so on. So there's clearly a link between all of these standards. And I will immediately take the second question as well, as it is related to liability. I'm not aware of how the timing will be. Now, of course, the normal procedure will start. The fact is that both proposals are linked to activities under the AI Act. They refer to the definition of artificial intelligence. They refer to the role of providers. So this is, of course, a good thing to ensure coordination. But considering that both instruments are really dependent upon activities, progress made by the AI Act, well, it has to be seen in light of that as well. Both proposals also provide some revision possibilities once they are adopted, because of course we do not know how AI and the regulation of it will evolve the coming years. But I would say I think it will largely depend upon like the evaluations of the AI Act. I saw a third question coming in, but I don't know if it's addressed to me or just more general. Well, I think maybe others can also comment on the fact that standardizations will not disadvantage SMEs. I do not know. Of course, when standards are being adopted and developed, our position of SMEs is taken into account. We have consumer interests, we have business interests. So it's a process in which they can voice their concern. But of course, this relates to the more broad question: regulation, innovation, and what is the impact of both of, or what is the interaction, the balance between both of these elements? And that is, I think, a more general question to which, I'm not have the clue. I don't have a clear one-cut answer.
Okay, thank you very much, Jan. I think we have to wrap up because we're already a bit over time. I would just like to thank all speakers for their presentations. I'd like to thank the guests for their questions and for attending this webinar. I would just like to draw your attention to two more things. The Knowledge Center Data and Society is organizing an end of the year event in Ghent on 14th of December. On that day, the Learning Community AI and Ethics in Practice will be launched. We are doing this to stimulate knowledge sharing between ethics officers, digital ethicists, AI ethics officers, and other professionals who are either directly or indirectly concerned with the subject. Everyone who encounters ethical challenges related to data-driven applications in AI in their professional practice is more than welcome to join us that day. More info on this event can be found on the Knowledge Center website. And second thing, finally, I would like to mention that all updates from the Knowledge Center's Policy Monitor, they're also posted on a dedicated LinkedIn page via this QR code. This code will direct you to the page where you can actually follow us. So then I think we can conclude here. Thank you everyone once again for participating, and until next time.
Thank you very much for organization. Bye-bye. Thanks, everyone.
Thank you. Bye.
Thank you. Bye.